depth of street knowledge. Witness the strength. Street knowledge. Street knowledge.
Terrorize the jam like troops in Pakistan.
Street knowledge. Street knowledge. Quick service announcement brought to you in part by Warriors.
Damn, that shit was dope.
And welcome back to some breaking news on Warrior Creed for an out of schedule live stream. Those of you who follow Radical Media will be aware that we've been live posting our notes from the court at the Midazolam death inquest of Derek Dimmock, which was being presided over by senior coroner Dr. Julian Morris from Southwark Coroner's Court in London. And the breaking news, as is in the title of the show today, Midazolam inquest suspended early after expert witness humiliates Royal Trinity Hospice. That's the topic for today's stream. And indeed, that's the breaking news. The coroner, Dr. Julian Morris, in a surprise move, suspended the inquest today with an entire day scheduled remaining, and that was today, Friday, remaining. The court presumably now sits empty. That's the main court at Southwark Coroner's Court. The witnesses, the expert witnesses, were in attendance. Professor Sam Ahmadzai, one of the country's leading palliative care or end-of-life care academics, was present on behalf of the family. Dr. Das, the court-appointed expert, was present. They were ready in the courtroom. They were scheduled on the docket to testify today, and then after merely 20 minutes, the coroner, in a surprise move, suspended the medical inquest. You can see the news on your screens now. Medical inquest into the Midazolam death of Derek Dimmock has concluded its second leg after only 20 minutes without hearing from the listed expert witnesses. It is set to resume sometime between December 2025 and February 2026. Many observers, including the Dimmock family, are very surprised that expert witnesses, Professor Sam Ahmadzai for the family and Dr. Das, court appointed, who were listed for today, were not heard, with the entire day in court now remaining free. That is what has been the breaking news, we should say, today. That's what has been revealed as the latest breaking news. It is something that has surprised the family. We are aware, having spoken to the Dimmock family, that they are incredibly surprised by these developments. And they have issued a letter. This is breaking news. The Dimmock family have published a letter that they have sent to the chief coroner of the United Kingdom and to the coroner presiding over this case at Southwark Coroner's Court, Dr. Julian Morris. And that letter has been already dispatched. It's been sent. It states in the letter that because this is a public inquiry, a public inquest, that the public has a right to know as well. And therefore, Radical Media is now able to break this letter to the public and read from it, from the Dimmock family, written by the son of Derek Dimmock, Paul Dimmock. It's on your screens now, and we read it for you. Urgent and important. Complaint about senior coroner Julian Morris. I'm writing this email following this morning's court hearing. Myself, my mother, my counsel, Professor Ahmadzai, Dr. Corbett, and all of the public that attended in court, some of who had traveled hundreds of miles, and those online, were under the clear impression that today's valuable court time was going to be for Professor Ahmadzai to give his expert evidence, as was listed all week and previous to this week. In the court listings for public viewing in the court, it had Dr. Corbett listed for Wednesday, the 13th of August, and Professor Ahmadzai listed for Thursday, the 14th of August. And to our understanding, they were both pushed back a day because earlier evidence took longer than expected. Dr. Corbett did as agreed and arranged to give his evidence on Thursday, the 14th of August. But for some inexplicable reason, Professor Ahmadzai was not permitted to give evidence today, 15th of August 2025, as previously agreed and scheduled. It came as a great shock to all of us when Senior Coroner Dr. Julia Morris ended the session today after approximately 20 minutes at Southwark Coroner's Court. Coroner Morris' main argument against any delay, which he indicated would take my father's inquest into 2026, 6 years after his death, was based upon him stating on many occasions that court availability is non-existent until February 2026, as the court is so busy. Yet now today, he had both counsel in front of him and Professor Ahmadzai, but the main court at Southwark Coroner's Court now sits empty for the rest of the day today, 15th of August 2025, despite the Dr. Morris claims of a lack of availability due to how busy the court is. To continue reading, none of the people named above were given an explanation as to why he did not hear Professor Ahmadzai's evidence live in person today. There is no logical reason that he has to hear Professor Ahmadzai's evidence in the same week as Dr. Das, if indeed that is his reasoning. In fact, various nurses involved gave evidence 5 months apart. The doubtless unintended consequence of the decision to terminate proceedings early on Friday morning, instead of continuing with the evidence to the end of Friday, will, I believe, be that the evidence of Dr. Corbett, given very powerfully yesterday, will make a much greater impact on a much wider audience than it might otherwise have done. Is that really what Coroner Morris wanted? In mine and my mother's opinion, Senior Coroner Dr. Julia Morris has shown bias in favour of Royal Trinity Hospice throughout the whole of this inquest in the way he has treated my counsel, compared to counsel for the hospice, in the way aggressively and almost contemptuously cross-examined Dr. Corbett, as opposed to the very friendly and smiley way he treated the hospice witnesses, and in his clear body language, as also reported by press watching online in March, and facial expressions toward the hospice counsel, Miss Amanda Wright-Kluger. The chumminess even went so far as childish giggling with Miss Wright-Kluger on the audio recordings in March 2025, with only counsel and him in court, but recorded on audio and witnessed by myself and my mother, produced by the court upon request from myself to Alexander Williams, court usher, and received from the court as per protocol. We're going to just break that down. That's half of the letter. We're going to read the other half in just a moment, but this is incredibly significant. The family, Paul, the son here of Derek Dimmock, have written a formal complaint to the coroner, to the chief coroner of the United Kingdom, and have in that complaint stated that they believe that the coroner is exhibiting bias towards the witnesses for the Royal Trinity Hospice, and indeed has prejudiced them by exhibiting that bias against expert witnesses provided by them, and has frustrated them by the further delays that they have suffered today when the inquest was suspended with an entire day remaining on schedule and no evidence was given for that suspension. It's an important point to note before we carry on reading from the second page of the Dimmock family letter. It is important to note that the suspension of this case today was not clearly a reason has not been given for that suspension, and yet clearly it's in the public interests to know that reason, because this is a public inquest. Being a public inquest, we, media, had the right to attend. We had the right to live comment on proceedings. You, members of the public, had the right to attend and had the right to live comment on proceedings as observers. It's a public inquest, and being as such, it is a matter of public interest to understand why the inquest was delayed today, and yet no reason has been provided by the senior coroner. No reason is discernible from his remarks yesterday. By all accounts, and Radical Media have sought clarification on this from the Dimmock family and the Dimmock family barrister, and the reports we have received back, the replies to our answers, is that no explanation has been provided to them, to their knowledge. And I say to their knowledge, barring any grave error that all of us have made simultaneously, including all the witnesses that attended the inquest today, the public witnesses and media, all the public and media, the Dimmock family and the Dimmock family barrister James Bogle KC have all expressed that they do not know why the inquest was suspended, and the reason remains a mystery to them, that nobody knows this reason from all those I named: the Dimmock family barrister, counsel James Bogle KC, and all the media that attended and the public that attended today. Nobody knows the reason for why this was suspended. So unless we've missed something glaring and have all made the same mistake, Senior Coroner Dr. Julian Morris has failed to provide a reason for suspending this inquest early, while an entire day remained free in the court for this precise purpose. And therefore, and we were in the court. It was an ongoing session. Therefore, it's not an issue of a lack of availability of courtrooms. Nobody, therefore, so far has heard any reason from the coroner, Dr. Julian Morris, as to why he's done this. And the absence of a reason provided at a public inquest in a public interest case is a glaring omission. And therefore, this omission by the coroner, Dr. Julian Morris, means it becomes in the public interests to ask publicly why this omission may have been committed. That's our logic for intervening as Radical Media so publicly at this stage, because it's a public inquest and a reason for the suspension of this inquest has not been provided to the public by the coroner. And therefore it becomes our duty as media, which we would be failing at if we did not ask publicly at this stage, what is the reason for the early suspension of this inquest when an entire day was remaining in court? What is the reason? This reason has not been provided, and therefore it's only natural for media who are scrutinizing this inquest in the name of the public interest, to then ponder aloud as to what those reasons may be on the strength of the evidence that has been so far provided at the inquest to date. And that's the only course of option that remains to us. And that is not to speculate wildly, not to theorize, but rather to ponder on the strength of the actual evidence provided on the last day of the inquest that it was heard, which was yesterday, before the brief 20 minutes this morning in which the announcement of the early suspension was made. But the actual evidence that was presented yesterday is the last logical and plausible reason that may have been for why today was suspended. And of course, that evidence yesterday was the evidence presented by the family expert witness, who well and truly, by all independent accounts, shone in his testimony, in his thoroughness and in his expertise and in his grace and dignity, while he abided the attempts by counsel for the Royal Trinity Hospice to not exclude only part of his testimony, as the coroner eventually did, but to exclude him entirely from the inquest as somebody that was, quote unquote, not expert enough to be an expert witness. Well, that was dismissed by the coroner, and the testimony of Dr. Kevin Corbett, that was provided yesterday, the expert testimony, thorough, professional, he's, as we say, to be lauded for that. That expert testimony was damning for the Royal Trinity Hospice. It was so damning that it was even evident from our media perspective. It was, and as witnesses to this, it was even so damning that it was even evident on the coroner's own body language and reactions. He had no choice but to accept not only the admissibility of the bulk of the relevant evidence provided by expert witness Dr. Kevin Corbett, but also to express on a number of occasions that he now understood what Dr. Corbett was getting at, whereas he previously may not have. That's all on the record in the court transcripts, the official transcripts, which we at Radical Media do not yet have, and the official videos, which we at Radical Media haven't yet had time to request, but of course have been receiving since the start of this inquest. But in our live notes, which are not official court transcripts. We remark on all of this from the Day 4 live notes that we've published on our Substack notes feed and our Twitter feed as well. We will republish all of this in tomorrow's Radical Dispatch for you. But for the meanwhile, we are going to, on that note, leave it with you on this point halfway through the Dimmock family letter to say that is the only logical speculation remaining, and that is that the only reason it could possibly be logically is on the strength of how damning Dr. Corbett's evidence was that was provided yesterday. The inquest, the coroner, and even counsel for Royal Trinity Hospice needed time, a break, to consider its implications. That's on the strength of the evidence. That's the only logical reason we can think of as to why this inquest was suspended without notice today after only 20 minutes into the day, with the entire day remaining on the schedule. And the Dimmock family, in their letter that they've written to the coroner and the chief coroner of the UK, their complaint, have also come to that conclusion. What we're going to do now is continue reading from the second page of the Dimmock family letter that we started the first page on for you just a moment ago. Because it's long, we thought we'd break it up. The second page. Childish jokes and giggling from Coroner Morris to counsel Miss Wright-Kluger show a clear sign of disrespect for the role he is carrying out and his duty to have respect for my late, much-loved father and for me and my family. Once again, I have no choice, and not for the first time in this investigation into my late father's death, to refer to the Chief Coroner Guidance number 9, which states the following, paragraph 31. In any event, coroners are reminded of the duty in all cases to complete the inquest as soon as is reasonably practicable, rule number 8 in brackets, and that unnecessary delay may cause additional anguish and distress. Paragraph 32 from the Chief Coroner's Guidance states, the importance of setting dates of hearings cannot be overemphasized. More complaints are made by families about the failure to set dates than any other topic. Uncertainty causes distress. Not setting a date frequently causes unnecessary delay. The letter by Paul Dimmock continues after citing that from the Chief Coroner's Guidance. A letter on behalf of the family was written on 4th of July 2023 by then MP Mr. Andrew Bridgen to the Chief Coroner, Mr. Thomas Teague, including the following statement. This is continuing from Paul Dimmock's letter. I'm just continuing to read. He's now quoting Andrew Bridgen, who wrote for him previously. In my capacity as an elected member of Parliament, I would politely but firmly request that everything possible is done to expedite the investigation and inquest into the death of Mr. Derek Dimmock despite these difficulties. Quite simply, the duty to prevent future deaths should be the overriding concern here. Investigation into whether Liverpool Care Pathway type treatments were provided at Royal Trinity Hospice and are still being provided should, in my opinion, be reason enough for an investigation and jury inquest to be brought forward, not delayed. That's the end of Andrew Bridgen's quote. Paul Dimmock continues in his letter. Myself and my mother can confirm that this unnecessary delay again today has caused us both additional anguish and distress, and we personally hold Senior Coroner Dr. Julian Morris responsible for that. After stating earlier this week that the court has absolutely no availability until February 2026, looking directly at my counsel and clearly trying to put pressure on him to ask fewer questions, if you will remember that. He then stated today that there may be availability on the 1st of December 2025. So after hurrying along James Bogle, King's counsel for the family, in his cross-examination of the Trinity Hospice's witnesses and using the reason for hurrying him along as saying that we don't have enough time, the coroner today leaves an entire day free and blank and doesn't hear the inquest. And after saying there's not enough time. And then after saying there's not enough time and hurrying along Bogle KC during his cross-examination, suddenly finds a slot in December that is available for the inquest. These are all glaring contradictions that the Dimmock letter is pointing to. The letter continues. I strongly object to his misleading me and my mother in that way. It is unacceptable. We've just explained that misleading. And it is even more unacceptable to use such misleading tactics to try to pressure my counsel into cutting down the questions that he must ask and that I and my mother wish him to ask. Even more so if the coroner is then going to leave court to stand free for a whole day when it could be used to continue the evidence. Again, that's the point we just explained. To continue reading. These delays, including multiple examples of incompetence by the Southwark Coroner's Court office, have to stop. My family and the wider public are relying on the court to carry out its duties properly and fairly, and those responsible for causing the delays should be held accountable. I can confirm that I've written this email/letter in conjunction with my mother, and I would like to make it clear it is a letter of complaint towards Senior Coroner Dr. Julian Morris. This letter will be copied to the Chief Coroner of England, Her Honour Judge Alexia Durran. In the best interests of the public, and especially given the need to prevent future deaths at Royal Trinity Hospice, I'll make my wording in this complaint letter available to the public. And now we're reading it, of course. Dr. Corbett's evidence yesterday. Now, this comes to when we just explained after reading the first half of the letter that the only reason that remains logically plausible on the strength of the evidence as to why this delay that has remained unexplained by omission by the coroner, as to why this delay occurred, the only logical reason is that the strength of the evidence yesterday of Dr. Kevin Corbett was such that it meant, and it was so strong in terms of its implications, that it meant the coroner and counsel for the Royal Trinity Hospice, the barrister Wright Kluger, needed time to digest the implications of Dr. Corbett's evidence, and Wright Kluger may have needed extra time to prepare a proper defense for the Royal Trinity Hospice, because Dr. Corbett's evidence was damning. And we're going to come to that evidence from our notes, live notes that we published yesterday, and show you exactly what was so damning about it. To continue from the Dimmock family's letter, Dr. Corbett's evidence yesterday regarding the workings of syringe drivers was in stark contrast to the evidence that Dr. Lund, who's the medical director of the Royal Trinity Hospice, gave in court earlier in the week on the same subject, i.e. syringe drivers. She is clearly deficient in her knowledge, Dr. Lund, that is, the medical director of the Royal Trinity Hospice, is clearly deficient in her knowledge of the workings of the syringe drivers in her own hospice. That is surely unacceptable and goes to the issue of preventing future deaths, which I hope Senior Coroner Morris will now bear carefully in mind. Senior Coroner Andrew Morris, it should say, had already raised the issue of preventing future deaths. Oh no, that was the coroner before him, because the coroner before him got switched around to become this one now, Julian Morris. So Senior Coroner Andrew Harris had already raised the issue of preventing future deaths at the hospice at the first PRRH, which was the first inquest hearing that wasn't yet in the court stage. It's a preliminary stage. With respect, I strongly recommend the Chief Coroner of England to obtain and listen to the audio recording of the first week of the inquest in March 2025, which will very much tend to prove my description of Senior Coroner Morris, inappropriate prompting and childish comments and giggling, which is clear to hear. In addition, Senior Coroner Morris fed the word intimidation to Miss Wright Kluger for her to make an entirely unjustified complaint about me, quote, staring at, unquote, the witnesses so that she could press the coroner to allow all the witnesses for the Royal Trinity Hospice to give their evidence remotely, which is what they eventually did. At no time did I, quote, stare at their witnesses, let alone with, quote, intimidation. That word, quote, intimidation was fed to Miss Wright Kluger by the coroner, which to myself and my mother was completely unacceptable, coming from a judge who should be impartial to all interested parties. Now, this is the substance of the complaint here, that Senior Coroner Dr. Julian Morris is showing bias in these proceedings. Please acknowledge receipt of this email with a response that has been received and will be given immediately and in its entirety to Senior Coroner Dr. Julian Morris and to the Chief Coroner. Yours sincerely, Mr. Paul Dimmock and Miss Maureen Dimmock. That concludes the letter that has been provided to Radical Media by the Dimmock family. We will publish that letter immediately as soon as this stream ends in the quote. We will quote this stream and publish a letter on top of it so that everyone has instant access to that letter. And of course, all the receipts from today's stream will be in the Radical Dispatch, probably tomorrow when we publish that as well. But of course, the letter referred to a number of points. It referred to a complaint against the senior coroner, Dr. Julian Morris, by the Dimmock family for showing bias and favourability towards Wright Kluger, the barrister for the Royal Trinity Hospice at which Derek Dimmock, their father, died. So the complaint of bias. There was also a complaint that the reason being given that the James Bowl KC had to hurry with his cross-examining the Royal Trinity Hospice witnesses, who were the medical staff, was because there wasn't enough time. And yet now suddenly the coroner suspends the inquest, leaving an entire day free. So either there wasn't enough time or time doesn't matter and we can waste days. The third point raised was that the coroner, when saying there wasn't enough time, was threatening that there were no other courtrooms available until February 2026. And that date was explicitly mentioned many times. And yet today, when wasting the entire day, the coroner then says that they have found availability for this December 2025. The letter goes on to say that as a result, this is a complaint for the reasons mentioned, and also that the letter has gone to the chief coroner of the UK, and that they would like the family would like a response to this complaint, because it's caused them distress to further delay this without hearing the evidence of the expert witness, Professor Sam Ahmadzai, who was scheduled today. The family, fifthly, has also then said in that letter that they are left with no conclusion but to speculate, like we have, that the reason for this delay, they point to it in this letter, was due to the weight of the evidence provided by Dr. Kevin Corbett yesterday on behalf of the family. That logical conclusion is the only one remaining in the context, the family didn't say this, we're saying this, in the context of the coroner omitting the reason being given for the suspension of the inquest. We're saying it remains the only logical reason, and that is the strength of what Dr. Corbett provided yesterday, and the implications of his evidence mean the coroner, and certainly the counsel for the Royal Trinity Hospice, need more time to decide how to respond to the weight of what Dr. Corbett said yesterday in his evidence that was indeed damning in against the Royal Trinity Hospice practices and in favour of the Dimmock family. So that's our conclusion from the letter we just read you. And of course, many online are also coming to a similar conclusion. These are some of the reactions you can see by posters online. One, Hannah Bentley, has said, the evidence of Dr. Corbett is utterly damning. No wonder their barrister is resorting to such blatantly desperate measures to exclude it. Let's pray that her fears that the truth is coming out will come to pass. Another poster underneath, Start with Human Lives, says, there's enough in that short segment from Dr. Kevin Corbett to make an information leaflet out of, just regarding the wrongs that were done after end-of-life prescription and administering, and how utterly unfit for purpose the process of death certification became, especially after COVID measures. We agree with those reactions. And we are also saying that it's very likely that it's on the strength of the evidence of Dr. Corbett that he gave yesterday that is likely the reason for this unexplained suspension today, this early suspension. And forgive us, we recognize that's mere analysis. We recognize it's mere posturing. However, absent a reason being provided for the unexplained suspension, early suspension of a public inquest, it becomes a matter of public interest for media to ask precisely this. If not for needing extra time to consider the expert evidence of Dr. Corbett yesterday, why was this inquest suspended? That is a question we formally pose over the course of this medium to the coroner, in addition to the Dimmock family complaint letter. Why was the inquest suspended without reason given? And our posturing that it's the strength of the evidence of Dr. Corbett requiring extra time because it's so weighty in its implications is responsible posturing, because it's posturing and speculation on the strength of the evidence. It's not wild speculation. We're saying on the strength of the evidence, and we know that why? Because counsel for Royal Trinity Hospice, Wright Kluger, attempted to have the witness, Dr. Corbett, struck off entirely from the inquest. That's how worried counsel for the Royal Trinity Hospice were about the evidence presented by Dr. Corbett, that they attempted to have him excluded entirely. So we must be forgiven for coming to the conclusion that is in the public interest regarding a public inquest about Midazolam deaths in this country. We will be forgiven for assuming that that's the reason, because not only did counsel for the Royal Trinity Hospice attempt to strike off the very powerful witness, Dr. Corbett, yesterday. But after they failed to succeed in getting him struck off, and upon continuing his cross-examination, most of what Dr. Corbett presented was so damning to the Royal Trinity Hospice that then, after trying to get him struck off and failing, that same counsel, Wright Kluger, then, after only 5 minutes of Dr. Corbett's being allowed and the coroner ruling that he will be allowed to remain as a witness, after roughly only 5 minutes of that decision being made, Wright Kluger, counsel for the Royal Trinity Hospice, then requested yet another timeout recess so she could go and reconsider her strategy in light of this damning news that very much damaged her case. She asked for 5 minutes in the inquest and ended up leaving the room for 20 minutes after the coroner allowed Dr. Corbett's evidence to remain. It was an unscheduled recess after already an hour and a half recess that came for another 20 minutes because Wright Kluger requested it because she panicked and needed to respond to the coroner allowing Dr. Corbett's evidence to remain. And it's why we've come to we believe, the responsible and based upon the legal evidence conclusion that may well be the reason for why the inquest was suspended today without reason being provided by the coroner, because the implications of what Dr. Corbett said yesterday are damning. And let us elaborate. And then we're going to show you all the receipts for this. And then we have to rush off because this was an emergency broadcast. We have to rush off to some personal duties. But we're going to show you some receipts first. But let's just clarify before we show you these receipts exactly what's going on. What could possibly be the implications of Dr. Corbett's evidence yesterday and how damning they are? What could possibly require so much extra time? Well, the issue is that if there are clear criminal implications in what's been revealed via Dr. Corbett's evidence, in other words, death due to criminal culpability, and we're not saying there are, we're saying if there are, then of course the coroner will need time to consider that based upon yesterday's evidence. And the coroner already twice alluded to, by using the word to James Bogle Casey for the family, he said, "You don't want me to caution the Trinity Hospice witness, do you?" Now, why would he say that? Because by cautioning a witness, he's reading them their quote unquote rights, known as the Miranda rights, for example, because the witness may end up incriminating themselves. That statement made by the coroner to James Bogle Casey, counsel on behalf of the family, the Dimmock family, that statement was made on day 4. And he said explicitly, "You don't want me to caution the Trinity Hospice witnesses, do you? Because if you carry on, I may have to." Alluding to the point that they may end up incriminating themselves. After Dr. Kevin Corbett presented his evidence, it became clear that this falls within the remit of consideration, at least, as to whether we're witnessing the unfolding of a criminal investigation, because Gosport Hospital was referenced this morning by the cross-examination, part 2 of the cross-examination of the doctor that was on the ward the night Derek Dimmock died, Dr. Wright. And that cross-examination by Bogle Casey this morning, and that was the 20 minutes that lasted this morning before the surprise suspension. In that cross-examination, Bogle revealed that Dr. Wright, who was on duty that night, Derek Dimmock died on the ward, that Dr. Wright had previously done an audit of the deaths at Gosport Hospital, which were deaths involving the overuse and misuse of opioids. And Dr. Wright had been fully aware of that because she had audited those deaths upon being asked, as she testified to in the 20 minutes this morning. Now, the interesting point is that those deaths at Gosport Hospital are subject to a criminal investigation. That's very interesting. So forgive us, on the strength of the evidence, it would not be an injustice if Dr. Julian Morris, the senior coroner presiding in this case, suspended the inquest this morning without warning, because he needs to look seriously at whether this becomes a criminal investigation. Currently, this is not a criminal investigation. This is a medical inquest. But if this becomes a criminal investigation, he will need to do 2 things in December when he resumes. Immediately, he would probably need to issue that notification that is in the Dimmock family letter, which we're just going to refer to again, that was already given in the very first PRRH by Coroner Harris, who's no longer the coroner. And that was a direction that needed to be considered because the avoiding future deaths directive, it's known as, because if it's revealed that these deaths could be ongoing due to these abysmal policies of the Trinity Hospice and those who have very similar or identical policies, then the coroner would need to rule on that before the end of this inquest anyway, to immediately stop any deaths that could come about. And as a result, one of the things the coroner may need time to consider, due to the evidence provided by Dr. Corbett yesterday, is whether or not in December, as soon as they resume, after having had time to digest what Dr. Corbett said yesterday, whether Coroner Morris, Julia Morris, needs to issue a preventing future deaths order in this inquest. And that's alluded to in the letter by the Dimmock family. It says, she is clearly deficient in her knowledge. Dr. Lund, the medical director of the Royal Trinity Hospice, is clearly deficient in her knowledge of the workings of syringe drivers in her own hospice. That is surely unacceptable and goes to the issue of preventing future deaths, which I hope Senior Coroner Morris will now bear carefully in mind. Senior Coroner Andrew Harris, who was the coroner in the first preliminary hearing, known as a PIRH, had already raised the issue of preventing future deaths at the hospice at the first PIRH. So it could be, and this is, as we say, this is not wild speculation, but this is reasonable conclusion based upon the strength of the evidence that we heard yesterday, that it could well be that the coroner needs time to consider Dr. Corbin's evidence and whether or not there are certain criminal consequences now involved. And now, before we're going to move to the evidence itself. Before we do, this is Dr. Corbett, who provided evidence yesterday on your screens now. That is from Dr. Kevin Corbett's LinkedIn page. We're going to show you what's from his LinkedIn page in a minute. That is a photo publicly available online, but of course, having met him personally, that is Dr. Kevin Corbett. And we're now going to explain to you what, from our notes of the evidence provided by Dr. Corbett, what potentially could be so embarrassing for the Royal Trinity Hospice. As we've said here on your screens, is this embarrassment yesterday why the coroner surprise adjourned the entire Midazolam death inquest today after only 20 minutes. And it is this that we're now referring back to our notes, which we will republish for everybody in the Radical Dispatch tomorrow. We will say at this stage, big caveat, these are not official court transcripts. These are our personal notes. Nevertheless, we've tried as best as possible to be accurate while listening to very complicated technical and legal jargon and typing at the same time. So do forgive us. These aren't word for word. These are notes, but they are reliable as far as we're concerned to get the gist of what was going on. And here's a highlight from our live notes. Barrister for the Royal Trinity Hospice, Wright Kluger, submits a surprise motion to the senior coroner to exclude expert witness Dr. Corbett from the evidence after he highlights from the submitted medical records that there was a serious, quote, medical error on the records for midazolam doses given to Derek Dimmock. Wright Kluger, and this is our live notes now, paraphrasing what she said, "Sir," to the coroner, "Sir, I would like to pause at this time to make a submission to you. You know what my submission is going to be. Sir, at this point in time, my submission is that from 1994, Dr. Corbett was academic. He cannot prescribe and has limited experience with syringe drivers, and his evidence should be discounted, and he should not be an expert in this case." The coroner, we've said in our live notes, referred then to the family barrister James Bogle KC for a response, and paraphrasing Bogle, "This submission is far too late in the day and should have been made much earlier." The coroner then, paraphrasing, says, "I think, to be fair, the submission has been made previously." Wright Kluger for Trinity Hospice then says, paraphrasing, "And sir, at that point, you indicated that we would explore that at the inquest itself. I'm now making that submission and asking for a formal ruling." Bogle then responds, paraphrasing, "I wonder if it might be if I might be able to finish." The coroner then allows Bogle to finish making his point, and Bogle says, paraphrasing, "It cannot possibly be right that this be sprung on the court at this late stage. If the submission is being entertained by the court, all that has been said is not much different to what has been said previously. You have already allowed the evidence to go in, and it is now in. The court can decide on the relevance. He doesn't need to be a subscriber to be able to deal with the questions." Sorry, a prescriber, that should read. These are the dangers of live notes as we post them. He doesn't need to be a prescriber to be able to deal with the questions that have been asked of him, and he does not need to have been practicing day in, day out to be able to speak about these issues. His evidence is entirely relevant. It would be hard to find a nurse in this country more qualified academically. He is probably one of the better qualified people in the country to be able to give that evidence. In our live notes, we then say, coroner declares a lunch break till 13:45 yesterday to consider whether or not Dr. Corbett, and this is him, was excluded. Now, as you just saw there, Wright Kluger was questioning Dr. Corbett's expertise. This is Dr. Corbett's LinkedIn page. This you can see there, Kevin Corbett, PhD, independent research consultant, health scientist, United Kingdom, ex-KPC Research and Consultancy Limited, London South Bank University. You can all go and check out his page yourselves. We assure you, having looked at his expertise, having met the man and having heard his expert testimony yesterday under oath, at risk of a criminal offense of lying under oath, his experience and CV is impressive in the health sector and goes back many years. In fact, we'd go so far as to saying the man is a bit of a hero. From what we heard him present yesterday in terms of evidence, worked in hospitals during the peak of the AIDS crisis, putting in place protocols for end of life at the peak of the AIDS crisis for all of our hospitals, literally writing the first educational curriculum for paramedics and then teaching it to them, teaching nurses some core fundamental protocols that are now common and everyday practice. The man was a pioneer in health education and curricula, and that was evidence from his testimony yesterday. We'd go so far as to say he's an NHS hero. That is genuinely our opinion of having heard him yesterday, and that opinion wasn't there the day before yesterday. Having met him, Dr. Corbett seemed like a nice enough chap. But having heard his evidence yesterday, we'd go so far as to say he's an NHS hero. And his evidence yesterday was damning. Dr. Wright Kluger attempted to have him excluded based on lack of expertise. That was laughable, and the coroner indeed dismissed it. But you can all go, if you're in doubt, to his LinkedIn page and check it out for yourselves. He is indeed qualified to testify on what he testified, and the coroner ruled as such anyway. Now, we're going to carry on that point, on the coroner's ruling, to read what happened next from our live notes. So it says, breaking, this is from yesterday, inquest resumes. Coroner addressing the issue of Dr. Wright Kluger's submission to dismiss Dr. Corbett as an expert witness. Coroner's decision. Dr. Corbett is not excluded as an expert witness for the medical inquest into the Royal Trinity Hospice and the Midazolam death of Derek Dimmock. Only a part of his testimony on cause of death is struck off, but his evidence on the medical error records for syringe drivers remains. And this is us now paraphrasing the coroner's decision. The coroner, paraphrased, says, he has heard... the coroner says he has heard not questioning the academic prowess of Dr. He's not questioning the academic prowess of Dr. Corbett. That's acknowledged by the court. I, meaning the coroner, highlighted to Mr. Bogle when he submitted that it was too late, that I had already addressed the issue as follows, that Dr. Corbett is not a practicing nurse and has submitted papers that are misleading and do not assist the work of Dr. Das, the expert of the court. That's the submission by Dr. Wright Kluger. The coroner responds, I said that whilst Dr. Corbett was not a doctor, his expertise was in need of clarification, and I had questions for him. Today is the inquest referred to in those directions. In other words, the time to ask those questions. For those reasons, I do, meaning the coroner, I do not take issue with the timing of the application made today. It's common ground that in respect of expert evidence, my guidance comes from the coroner's guidance. An expert is defined as a witness who provides to the court a statement of opinion on any admissible matter and who is qualified to give such an opinion. That's from the coroner's guidance. To continue paraphrasing the coroner after he read that guidance, in addition to my role in answering the 4 questions, coronial guidance does not lay down any criteria for considering expert evidence. Does Corbett have the appropriate experience or expertise? As I have indicated, I said, and to continue reading and paraphrasing from what the coroner said yesterday, the appropriate experience or expertise. I have indicated, as I said, matters would likely come to light at the inquest. Without doubt, Dr. Corbett has expertise. His evidence described his work, as he describes it, with palliative care, reflected in the many part-time palliative care positions, such as in hospital. His roles have also been focused in the training of nurses and other medical professionals. He clearly has expertise. The question is it the correct type? From my perspective, he also entered into areas that were not his expertise, and he should have made it clearer that the areas had fallen out of expertise. I'm going to rule out some of Dr. Corbett's evidence that includes his evidence that Dr. Corbett did not die, Dimmock did not die of heart failure. That should say Dimmock did not die of heart failure. Again, apologies. These are our live notes, typing as fast as we can while listening to technical and legal and medical conversations. To carry on reading, paraphrasing from the coroner, and includes his evidence that Derek Dimmock died of COVID-19, although we didn't discuss COVID-19 this morning. His experience in a hospice setting was back in 1995. He hasn't worked in a hospice since then. Taking all the submissions and evidence into account, my initial directions, as I put in the directions on the 24th of June, will remain. Dr. Corbett's evidence has helped me understand. Remember, we said earlier, we referenced it in our notes. This is where the coroner's entire body language and demeanor and tone changed when he said, Dr. Corbett's evidence has helped me understand some issues that I did not from his statement. This is the part that was damning for Wright Kluger, the barrister counsel for the Royal Trinity Hospice, where Derek Dimmock died. Carry on reading from paraphrasing from the coroner. I'm going to allow Dr. Corbett to provide evidence on the syringe drivers, but not on the effects of mixing pharmaceuticals. That will be provided, no doubt, by Drs. Das, the court witness, and Professor Amazai, the witness for the family, who actually weren't allowed to testify today. Then we say coroner agrees to proceed. And Wright Kluger for the Royal Trinity Hospice then asks for a 5-minute recess to consider her notes after this ruling. The coroner agrees and the court rises. That was the emergency recess that the counsel for the Royal Trinity Hospice asked for yesterday after the ruling, which had already come after 1.5 hour lunch break. After that ruling where the coroner ruled that Dr. Corbett could indeed remain as a witness, counsel for the Royal Trinity Hospice, Wright Kluger, demanded a 5-minute break and took a 20-minute break. And you can see our post there, breaking news from yesterday's live notes. Barrister Wright Kluger for Royal Trinity Hospice requested 5 minutes crisis break. She didn't use the word crisis, we did, to, quote, consider her notes. After her submission to strike Dr. Corbett off entirely from the inquest evidence was dismissed by the senior coroner, and that break has now lasted over 20 minutes. We remain in recess. When it was eventually resumed, by the way, Wright Kluger continued to cross-examine Dr. Corbett, and it only got worse for them, for the Royal Trinity Hospice and for Wright Kluger, and we'll come to that in a minute. But the specific passage that the coroner ruled in that ruling we just read to you and paraphrased for why Dr. Corbett should be allowed to remain because of his expertise in a specific area. That was the area of recording, errors of recording in that nurses and medical professionals who are present with the syringe drivers should be doing, recording the errors and noting them in their notes. Dr. Corbett, as a health educationalist, his expertise in whether or not those notes are in error is what the coroner ruled that he was allowed to be an expert on. And so now we're going to show you from our live notes, paraphrasing Dr. Corbett's testimony, precisely what he said about the recording of the syringe drivers. Before we do, we need to explain to everybody what a syringe driver is. The syringe driver is the thing that pumps the midazolam and morphine into the patient's body. In the case of Derek Dimmock, as the family's alleging, that's what killed him. Now, clearly, we know midazolam is a death row drug. We know it slows down the respiratory system. And of course, morphine as a painkiller and a delirium means that this can all happen while the patient stops breathing due to midazolam, and they're basically under the influence of the delirious opiate, morphine or any other form of opioid. Now, Corbett, the syringe driver, there was an error. The Royal Trinity Hospice do not dispute there were 2 errors in Derek Dimmock's syringe driver, but they've tried to explain them away by saying we fixed the errors by just whatever, fiddling with it. And this is what Dr. Corbett said about that. It's on your screens now. This is our live notes from day 4 yesterday. Again, forgive us. This is paraphrasing. We tried our best. This is not an official court transcript. Dr. Corbett, in response, says to Wright Kluger under his cross-examination, to the coroner, yes, but that explains it. But the line priming is different with the first prescription, so there's some variation. After the evidence, I accept 17.1. I'd like to know why it differed. What he's talking about is that there were 4 prescriptions given for those syringe drivers. The first 3 are incomplete. The 4th one is, according to Dr. Corbett, a gold standard for how it should have been done. And we'll explain now from these paraphrase notes. So the coroner says, can you explain how you come to the next conclusion? This is a key part. Dr. Corbett says, at the time I wrote this, I didn't have Nurse Lamb's incident form. The device alarmed. You get this flashing light, the deduction of slowness. I can't work out how this was deduced when you look at the flow rate. If you look at the volume infused that you project from 17.1 and project forward, the 0122 time, it's 11.2. So it goes up, right? Then it's 11.5. You see, it goes up, right? So it's at 11.2 at 1:22 in the morning. The syringe driver shows that Derek Dimmock got a dose at 11.2. Then it goes faulty. And then after the fault is fixed, it goes up to 11.5 as the volume that was remaining, right? And Dr. Corbett is confused. So we're going to carry on reading. It says, then it's 11.5. When it's saying it's faulty, you get an increase in the volume. So after the fault, you would have presumed that if it's being injecting into Derek Dimmock, that the volume would go down. It was 11.2. After the fault, it went up. And it was 11.5. So what? How could the midazolam go back out of Derek Dimmock's body, back into the syringe driver? Why was the reading higher of the volume left in the syringe driver after the fault than it was prior to the fault? This is the point that Dr. Corbett lasered in on, and we're going to carry on reading. From the middle of the second paragraph there, the big paragraph in the middle. He goes, at 1:22, it's 11.2, then it's 11.5. When it's saying it's faulty, you get an increase in the volume. So it seems to be working okay, but after that, you can't trust anything because the device is faulty. You can't record how much has gone in unless you record the discarded volume. The coroner responds, paraphrasing, let's say it was working normally. You would expect the 11.2 to go down for the sake of argument to say 10. Here, it's 11.5. In other words, the coroner's accepting it went up after the fault. The volume in the syringe driver of the drugs increased after the fault, not decreased. So how could it have gone back out of Derek Dimmock's body into the syringe driver? Something was wrong. And the coroner says he accepts that. And he says to Dr. Corbett, reading again from the last section, bottom of the page, coroner, let's say it was working normally. You would expect the 11.2 to go down for the sake of argument to 10. Here, it's 11.5. We heard evidence as to why it might be 11.5, but what I don't understand is the submission that it may have given more. But we just don't know. When the volume is in effect, even if we say it's 11.2 and stayed at 11.2, the volume is about the same. Dr. Corbett responds, paraphrasing from our live notes on day 4, because there's no volume discarded. Now, this is the key part. They did not record out those 4 prescriptions we told you that were for the syringe driver that went with the drugs, midazolam and morphine, that went into Derek Dimmock. 3 of those prescriptions did not record the volume of drug discarded, right? We're going to carry on reading. Because there's no volume discarded. And then the coroner says, paraphrasing, but if the volume in the syringe is around the same and hasn't changed, and then Dr. Corbett says, paraphrasing, but when you look at Lamb's, I can't see any record of the volume. She's done it by time, and that seems logical, decreased by 3 minutes, but the volume, that's 11.5, can't be trusted. Anything after the error can't be trusted. And then the coroner says, so what you're saying, it might have been less, we don't know. Dr. Corbett says, the dose delivered, you just can't calculate. Obviously, me writing that I did it with some trepidation because it's the worst outcome, but you have to look at the worst. There's no record of the volume that was left. The 4th combined prescription does have the volume, the time, and the person who did it. That's ideal. That's good. So the 4th prescription was good, as he says. And then the coroner responds, we had Dr. Lund yesterday who admitted that some of the writing was not as expected. So now even the coroner's forced to concede that the medical director of the Royal Trinity Hospice has admitted under oath in the inquest that these records were wrong and that they can't be relied on because some of the writing was not as desired, right? Dr. Corbett continues to drill down, bottom of the page, right? Down at the last paragraph, Dr. Corbett says, well, sorry, I don't agree. It's an error. You don't give it. It's a drug error. I've spent years in supervision. Now we have a much better system with this. These are serious. These are not just suppositories. And also with midazolam, I'm correct in saying it's a Schedule 3 controlled drug. It's not just paracetamol. For goodness sake, he's right. It's not just bloody paracetamol. You're injecting a death row drug into patients. There's been a fault in the machine. The volume before the error was 11.2. It looks like it's gone up, which means the entire thing's bonkers because drugs can't go back out of a system of a human being back into the machine. Instead of discarding that machine, they tinkered with it and continued using it. And then Derek Dimmock dies. And as Dr. Corbett says, this isn't paracetamol. You're not playing around with some harmless substance. This is a very serious Schedule 3 controlled drug. And you reuse that faulty machine. This is damning. It's damning evidence. And it's the evidence that it's the evidence that Wright-Kluger attempted to have dismissed in her surprise motion yesterday, that then the coroner ruled no, must stay in record as evidence, right? So that's how desperate they were, how damning it was that the Royal Trinity Hospice Council attempted to have it dismissed. The coroner rules it must stay, and then Wright-Kluger takes an emergency 5-minute break after that ruling that it must stay, and the break lasts for 20 minutes. But when they got back after that emergency 5-minute break that lasted for 20 minutes, Wright-Kluger attempted to begin restart her cross-examination of Dr. Corbett after having just tried to dismiss him entirely as a witness from the inquest because he wasn't qualified. But now it was ruled he was qualified. She had no choice but to attempt to continue cross-examining him, and it only got worse for her. Because this is what was then revealed by Dr. Corbett and the coroner. So just finishing off from the coroner, and what you're saying is that it's insufficient to put the volume registered by the syringe driver at 11.5. You can't rely on that data because the pump wasn't working correctly. Dr. Corbett responded to the coroner, exactly. Have I explained that to your satisfaction? The coroner says, yes, let's move on. Dr. Corbett then just says, can I just explain? That fourth prescription is the template that I used as the standard. It had everything in it. The other three cannot be used. Everything else is noise. The one thing that was needed in those prescriptions, that it was left out. In other words, the volume discarded. So you just don't know. You see, so that was damning yesterday. And then when Wright-Kluger, after her panicked 20-minute break, decides to restart cross-examination with Dr. Corbett, the following is what was revealed. This is now from Wright-Kluger's cross-examination of Dr. Corbett. And she says, and how often have you done a 5-page initial assessment of a patient? Dr. Corbett says, I've done many assessments in the 5 years that he was practicing in a hospice. Wright-Kluger then says, but have you? And Dr. Corbett says, could you just let me finish? I sat through the evidence as it was read there when it was presented in the court. I just don't understand how a face-to-face assessment, right? It's a face-to-face assessment that's being alleged by the hospital medical staff, how it can have been made before the patient has arrived in the hospital. They were claiming they made a face-to-face assessment, but the timing was before the face-to-face patient had arrived in the hospital. And this is what Dr. Corbett was testifying in terms of errors of record, which is what he teaches. And so it only got worse for Wright-Kluger. The coroner then interjects, Dr. Corbett, that's for me to rule on. In other words, please stop. It's going to become a potential criminal offense. Stop. That's for me to rule on as to why the time that it was alleged a face-to-face assessment was made was before the patient was even in the hospital. The coroner stops Dr. Corbett and says, that's for me to rule on as the coroner before anyone prejudices themselves in the inquest. He says, I appreciate your question, but that's for me to rule on. Dr. Corbett says, but can I just ask, sir? The coroner says, ask about what? Dr. Corbett says, about your judgment. The coroner says, no. And then James Bogle for the family says, sir, I think we should know what area Dr. Corbett is not allowed to ask about. All very interesting, isn't it? We're going to publish all of this in tomorrow's Radical Dispatch. You can go to the live notes yourself on our Twitter feed and on our Substack notes feed and read all of this for yourself. They're very long, so we're giving you just the highlights, and we're going to publish these highlights tomorrow. But to continue reading from what we're calling Corbett Returns, Wright-Kluger, her cross-examination tries to carry on. She says, Dr. Corbett, I understand that the lens with which you are saying this, you do accept that putting in the amount to discard is not a legal requirement. So then Wright-Kluger, appearing desperate, acknowledges that the amount of drugs discarded from a faulty syringe driver when it was all changed about were not recorded, and therefore it's impossible to know how much volume went into Derek Dimmock without knowing the amounts discarded, right? Very simple logical point. Those amounts discarded were not recorded. Wright-Kluger then, on behalf of Royal Trinity Hospice, in a desperate attempt, after having attempted to have this witness excluded entirely, then attempts to say, okay, but it's not a legal requirement to record the amounts discarded, which was understandably very confusing for Dr. Corbett, who was clearly metaphorically scratching his head and saying, but it's a bloody logical requirement. If you're going to claim that you know how much drugs went into Derek Dimmock, You need to know how much was left in the machine. And you didn't record the amount discarded. So you don't know how much was left in the machine. So you don't know how much went into Derek Dimmock. It's a logical requirement, even if it's not a quote unquote legal requirement. But here, this is Dr. Corbett's response. He says to Wright Kluger, after her asking, it's not a legal requirement, Dr. Corbett says, what do you mean legal requirement? Do you mean an act of parliament? Wright Kluger says, any mandatory requirement. Dr. Corbett says, the hospital policy, which is a mandatory requirement for staff. So Dr. Corbett says the hospital policy states that prescription doses must be recorded. Wright Kluger responds, it doesn't state that the amount discarded must be recorded. How would you know the dose if the amount discarded is not recorded, right? Which is exactly what Dr. Corbett then says. You cannot determine the dose given without noting the amount discarded. Right, Kluger then responds, which we didn't catch, and then Dr. Corbett says, where does it say that? I don't remember hearing that. It's not administered, therefore it shouldn't be recorded. Right, so we remember now. What Wright Kluger said there, which we didn't write, was the amount administered is what needs to be recorded, is official hospice policy, and not the amount discarded again. And Dr. Corbett replies, where does it say that? I don't remember hearing that. It's not administered, therefore it shouldn't be recorded. I can't see what's controversial about that. I taught this for 35 years. Now, we can assure you, having heard this live, it was said in as much exasperation as is reasonably we're attempting to recreate here for you. Dr. Corbett at the time said, I taught this for 35 years and we all abide by this. It's simply not good enough. Why do all this? It's simply not good enough. Just put the volume discarded on there. And what's the policy on discarded drugs? It's not there. I mean, was this a discarded drug put down the sink? It was a controlled drug. Surely you must have a witness, especially after shipment. Dr. Harold Shipman and the scandal there that's referencing. I'm not saying that the Royal Trinity Hospice is as bad as Shipman, but it's just common sense that you need to have policies in place. To continue reading from Corbyn Returns, part 3, James Bogle. Oh no, sorry, that's not to continue reading. We're going to come to that in a second. So those were the highlights from Dr. Corbett's testimony. It's so damning on the specifics of how we do not know how much midazolam was put in Derek Dimmock's body because they were using syringe drivers without recording the amounts discarded from those syringe drivers after having changed them around and topping up the drugs. That was all presented as yesterday by a witness that's expert enough that the coroner ruled he was expert enough after the barrister for the Royal Trinity Hospice attempted to have him dismissed. Now, the series of events that occurred after that, including the 1.5-hour lunch break that was taken to decide whether or not he would be dismissed as a witness, and then the extra 20-minute break that was taken immediately after the coroner ruled that Dr. Corbett would remain as a witness, Wright Kluger then took that 20-minute break to determine what to do next and to consult her notes, as she said. And then this morning's events, where the entire inquest was suspended an entire day early, forgive us. We have no option but to come to the conclusion on the strength of the legal evidence and the events unfolded yesterday that was the reason why the coroner needed extra time and suspended the entire inquest today, because the legal and potentially criminal implications of what Dr. Corbett said yesterday need to be considered by everybody, not least by the coroner. And finally, what we accidentally showed you early, a highlight we're going to now show you from day 3, 2 days ago now. And that was similarly damning. And this one you can see on your screens. We'll just read it. James Bogle Casey. This is from day 3. We're paraphrasing for the Dimmock family, cross-examining today. We're aware that the controlled drugs record was destroyed. Do you know when? The medical director of the Royal Trinity Hospice, Dr. Lund, testifying at cross-examination today, that was 3 days ago, said, may I see my statement about that? Bogle Casey says yes. Dr. Lund, the medical director of the Royal Trinity Hospice, says the book was destroyed in July 2022. Bogle Casey says, at that time, did the management know a complaint had been made by the Dimmock family? Medical director of the hospice, Dr. Lund, says the hospice knew that a complaint had been made. Bogle King's counsel says the management, your trustees. Dr. Lund for the Royal Trinity Hospice says no. Bogle for the family then says, were you aware? Dr. Lund says yes. Radical media note. Hospice director and former CEO of NICE, the body that formulated the NG-163 Midazolam protocol, Sir Andrew Dillon, resigned from the Royal Trinity Hospice when this medical inquest began. And as you can see at the bottom there, quoting our own post, August the 13th, that's from day 3 of this inquest. Interesting to note that not only had Sir Andrew Dillon already resigned, now the medical director of the Royal Trinity Hospice on day 3 admitted that they were aware of the Dimmock family complaint raised about the death of Derek Dimmock, and yet still decided to destroy the hospital's medical record book. Dr. Lund was personally aware and decided to destroy the stock book. That's the drug stock book of the weapon. Now put 2 and 2 together, all of you watching. Don't look at us, just put 2 and 2 together. Dr. Corbett said the amount discarded from the so-called faulty syringe drivers wasn't recorded, which it wasn't in the first 3 prescriptions for Derek Dimmock. Only in the 4th prescription given to him was the amount discarded recorded. And therefore, it's impossible to work out how much of midazolam and morphine was injected into Derek Dimmock during those first 3 prescriptions, because the amount discarded was not recorded. But you know where you could work out the amount discarded from? From the original stock that was in the medical cupboard for the Royal Trinity Hospice. And Dr. Lund just testified that despite being aware of Derek Dimmock's, Paul Dimmock, the Dimmock family's complaint about the death of Derek Dimmock, despite being aware of that complaint, she proceeded to destroy that medical stock book. Now imagine we had that medical stock book. You would have known how much midazolam they had to start with. And so even if the amount discarded hadn't been recorded, you could then work out how much was put into Derek Dimmock. But without knowing the amount discarded and without knowing the starting point of their stock, it's impossible to determine how much midazolam they injected into Derek Dimmock. And the amount that was originally in stock, their starting amount for midazolam, was in a book called The Medical Record that the medical director of the Royal Trinity Hospice destroyed, despite knowing that the Dimmock family had raised a complaint into the death of their father. That all came out in this inquest over the last 2 days. It's all a matter of court record. It's not just our live notes that recorded it as it happened. It's formal, official court record. We watched it live as it happened, so take it from us as an eyewitness. That all came out, and then today the coroner suspends the inquest without reason given. Are they considering criminal implications? Who knows? With understandably, hopefully you understand why we would ask so. That's all we've got time for today on this Warrior Creed live stream. We'll return tomorrow. We will publish the written version of this dispatch tomorrow, and we will try and return to our stream for the regular time next week. But thank you for tuning in.
You are now about to witness the strength of street knowledge. Witness the strength. Street knowledge. Street knowledge.
Terrorize the jam like troops in Pakistan.
Street knowledge. Street knowledge. Quick service announcement brought to you in part by Warrior